to speak to you in this hall, where I used to give lectures more than 60 years ago. I had classes here of 120 students, generally 40 advocate students and 80 proctor students. And year after year, I remember speaking in this hall 60 years ago. Those are wonderful memories. I must also thank all of you for your attendance. You are a very distinguished audience of lawyers, as well as a very concerned audience of students. There are huge problems that confront the law today, and all of you are naturally interested in finding ways and means of addressing these problems. And may I tell you that the world is in a very sorry state today, because we have so many conflicts raging around the world, over 40 conflicts, and over 100,000 people killed even last year in these conflicts. And can we claim to be civilized if all this is going on around the world and people are killing each other and not understanding each other? When all religions teach us that we are one human family, we must know each other, understand each other, help each other, love each other. What are we doing? We are doing absolutely the contrary in so many spheres. And what is the reason for that? Now I must thank the organizers of this conference for giving me the opportunity of speaking, because this is a topic that is of absolute importance in the world today. And I have analyzed it as resulting from the separation of law, whether it be domestic law or international law, from its religious foundation. Law is based upon the highest principles of morality and conduct as taught by all the religions. That's what it should be. That's what it is. But we are far too, shall we say, we pay far too much lip service to the law and far too much disservice to the law when we do not follow what the law teaches us. And my analysis of the situation is that this is due to the separation of law from religion. Now when law began, wherever it began, it was something that was connected with religious teaching. You look at any place, you will find whatever their concept was of the divinity and their concept of their duty to their neighbor, their duty to future generations, their duty to the environment, their duty to be peaceful with each other, their duty to resolve disputes peacefully, their duty to observe humanitarian conduct, their duty to honor their agreements and treaties. All religions and cultures taught the same thing. You look at the holy books of all the religions, you will find these principles enshrined in them. Law and international law took its origin from them, and also from the highest thinking of philosophers. There is something common to us all as human beings. As Aristotle said, fire burns equally whether here or in Persia. Now he was writing of Greece and Persia, but fire burns equally whether here or in Persia. There is something that applies universally. Even Cicero, in his defense of Milo, he said that there is in us, inborn within us, a sense of what is right and wrong. It is something not that was embodied in the law and taught to us as such. Each of us has this inborn facility of knowing what is right and wrong. And religion came and enriched this considerably. But what has happened is that the biggest reservoir of religious wisdom, which we as human beings have inherited, are the religious teachings of all the great religions. But we put that aside when it comes to law. Law is separate from religion. Now the connection between law and religion continued over the centuries, but very unfortunately, especially in the 17th century, there were some terrible wars of religion. You will remember the 30 Years' War that raged between 1618 and 1648. Now, in that war, thousands of Christians were killing thousands of Christians in the name of Christianity. Now, what could be more absurd than that? So, there were great writers who saw the breakup of the Holy Roman Empire and even the reduction in the authority of the papacy as resulting in a whole new number of principalities and dukedoms and so on, emerging as new countries. And they foresaw that with the decline in religious authority, these principalities, when they severed their connection from the overarching dominion of the Holy Roman Empire or the papacy, that they would be in conflict with each other and that the law of the jungles should prevail. So there were very great scholars, the most notable of whom was Hugo Grotius. All of you know him through his connection with the Roman Dutch law. And he wrote his great book on war and peace in 1625. Remember that date, 1625. But that was in the midst of the 30 Years' War, which ranged from 1618 to 1648. So Grotius reasoned, and quite rightly at that time, that this new discipline of international law, which he was trying to create, should be separated from religion. Because when you entangled it with religion, there was religious controversy, even within the same religion. So he said, we'll have this as a separate discipline. Now, Grotius would have been right in his time, but we are totally wrong in our time in disregarding this immense reservoir of wisdom which belongs to the whole of humanity, which has been bequeathed to us by the great religions. So, one of my missions has been to try to reintegrate religion into international law. And that's what I'm trying to do. Now, international law, as it started, very much saying the European context, it tended to be a Euro-centered body of international law. European countries thought that international law should be based upon their Christian heritage and so on, and more on their European interests. And they were anxious at that time, 16th, 17th, 18th, 19th centuries, to go out and colonize the world. So it was like a set of rules they worked out for themselves as members of an elitist club. Now that sort of international law will not do for the whole world. Of course, lawyers now realize that international law has to be for the entire world, and they are trying to liberalize it. But still, even when I went to the international court, I found that the law they administered was very largely Euro-centered law. It was very largely a body of law that was based on European tradition and the way in which Europe had formed a sort of select club of affluent states, and they were trying to rule the world in accordance with this set of rules. So that is the way that modern international law evolved. Not that that was the origin of international law. International law had evolved in a much richer sense earlier, even thousands of years earlier. But it had got distorted into this unicultural, Eurocentric form. So now we are still suffering from that to a large extent. But in my days in the international court, I did my best to indicate that all the religions, all the cultures of the world are the basis of international law. And that must be brought into consideration. In several of my judgments, I introduced various items from Hindu teaching, Buddhist teaching, Islamic teaching, and so on, to show how all those teachings could reinforce the authority of international law. Now let me give you a couple of examples. The wisdom of Hindu law and Buddhism was so great that more than 2,000 years ago, they saw that the future sovereign of the world would not be a physical emperor, not a chakravarti, not a man who tries to rule by physical force. The future ruler of the world will be, is a beautiful phrase, the kingless authority of the law. Remember that, how beautiful that is. The kingless authority of the law will be the sovereign of the one world of the future. Now that is international law. So Buddhism and Hinduism both taught that. And both these regions, as well as all the others, had rules pertinent to international law. Now, I was on the court. When the court was called upon to decide, reference from the General Assembly to the International Court, asking for a legal opinion on the legality or otherwise of nuclear weapons. The court was divided on that. They all condemned the nuclear weapon, but by a majority of one vote, in fact, by the casting vote of the President, they left open one small loophole. They condemned the weapon absolutely, but they said that they did not wish to express an opinion in regard to that situation where a country was under attack and its very survival was at stake. Whether that country could use the nuclear weapon in those circumstances. So by the casting vote of the President, we were divided, we have 15 judges, we were divided 7-7 because one judge had died before the case. There were 7-7. The President gave his casting vote in favor of leaving this little loophole for the use of the bomb. I disagreed totally, and I wrote an opinion, going to over 100 pages, saying that the nuclear weapon, the very conception of the nuclear weapon, the very production, storage, transport, research, whatever it is all absolutely illegal. And I reinforced my opinion from all the religions of the world. And one example, which will interest all of you, was from Hinduism. When Rama was having his war against Ravana of Sri Lanka, there was, I think, some kind of nuclear or other very advanced science in India at that time. Ravana was told that there was a hyper-destructive weapon available which could ravage the enemy's countryside and decimate his population. But then Rama was told, of course we have the laws of this country, laws of our civilization. You have to consult the sages of the law before you decide to use the weapon. And the sages of the law gave their opinion that such a weapon cannot be used in warfare. Why? The purpose of warfare is to subdue your opponent and live in peace with him thereafter, not to ravage his countryside and decimate his population. And Rama, unlike the rulers of today, took the advice of his legal advisors and did not use the weapon. That is in the Ramayana. That is historical record to show that our ancient civilizations had rules which would have absolutely prohibited the nuclear bomb. But in our so-called advanced civilization, we do not see anything wrong. As a matter of interest, in the 11th or 12th century, the crossbow was invented. The bow is too fast. The crossbow increases the velocity of the arrow to a great extent. And then the religions were concerned, Christianity, the Christian church, was very concerned as to whether this weapon could be used in war. There was a Lateran Council meeting of the Catholic Church in the 12th century, and they considered this newly invented savage weapon, the crossbow. And they said this weapon is too cruel to be used in warfare among civilized nations. So those civilized nations decided that the crossbow was too cruel to be used in warfare. But they don't see that the nuclear weapon is cruel. It is so absurd. And just another example like that. In the middle of the 19th century, around about the 1850s, the dum-dum bullet was invented. The dum-dum bullet is a bullet, when it enters the human body, it explodes. So it causes terrible suffering to the victim. So all the nations of the world, at that time they called themselves the civilized nations, they met in conference in the middle of the 19th century and said that the crossbow, that the dum-dum bullet was too cruel to be used in warfare among civilized nations. That prohibition still stands. So while we prohibit the dum-dum bullet, we do not prohibit the nuclear weapon. All the savagery of Genghis Khan